All right, let us go ahead and get started. Thank you all for being here today for our panel discussion, Overcriminalization, Getting Rid of Unnecessary Criminal Laws. My name is Vikrant Reddy. I'm a policy analyst at the Texas Public Policy Foundation. I also work with our National Right on Crime campaign, and I'm going to be today's moderator. I want to start by recognizing the director of our center, Mark Levin, who's sitting up front. Everybody knows Mark, and you know that Mark has been involved in this area for a very long time. Mark's kind of been the intellectual architect behind a lot of our overcriminalization work. And in fact, I thought I would start by telling an interesting story that involves Mark that occurred last year. Don't worry, Mark, it's not embarrassing. It was in the middle of the legislative session. It was March, and we were very busy. We were working quite hard, and we got an unusual phone call. It came from PolitiFact. And they said that they were going to be fact-checking Scott Henson, actually, who's sitting in the back row there. He's a local criminal justice gadfly, Scott, perhaps we could say. They said that Scott was going around town saying that there were 11 different felonies in the state of Texas related simply to oysters. And this couldn't possibly be true, and they wanted to know where Scott got his numbers. And he said, well, I got them from Mark Levin at the Texas Public Policy Foundation. So they called us up and they said, we're going to fact-check Mark and his oyster point. So they looked at it, and I'm sad to say that Mark was only given a mostly true, because they said that there are different methodologies for counting oyster crimes, and there aren't necessarily 11. There could actually be 16. In fairness, under another count, they said there could be 7. Well, you know, if your point is that we are over-criminalized in the state of Texas, whether it's 7, whether it's 11, as I believe the correct count is, or it's 16, it's far too many. And I think it's worth it. Well, I should also note, they did go to the Texas Department of Parks and Wildlife and ask somebody about this question of all the oyster crimes, and the response was, well, we take it very seriously. An oyster can kill you. You know, I guess that is actually correct. You could die from a bad oyster, you know, that happens, but I'm not really sure that that's the end of the matter. There are all kinds of things that could kill you. There are all sorts of things that are dangerous. The question is how you address behavior in society and whether or not criminal sanctions, whether or not making these things felonies, whether or not saying that a person could possibly be incarcerated is really the appropriate way to go about regulating these kinds of activities. You have civil sanctions, you have administrative fines, you have all kinds of ways to handle behavior, and yet we have this impulse in society to criminalize constantly. And I think it's worth thinking about, talking about, asking why it happens, and asking whether or not that's really the best way to address these challenges. To do that today, we've got an outstanding panel. And I say that because I actually know all 4 of the panelists. I've seen all of them speak before, and they're all dynamite, so I'm really excited about what we have today. We're going to start with Paul Larkin from the Heritage Foundation, who's visiting us today from Washington, D.C. Paul is the Senior Legal Research Fellow at Heritage. He has his undergraduate degree from Washington and Lee. He took his law degree from Stanford Law School, and he's got a master's in public policy from George Washington University. He's been a lawyer at DOJ. He has been counsel to the Senate Judiciary Committee. Paul he worked briefly for Verizon as counsel. He was an agent for the EPA, and he has argued in front of the United States Supreme Court 27 times. He's going to sort of set the table intellectually for our overcrim topic today, and I'm very proud to welcome Paul Larkin.
Vikrant, thank you very much for that very generous introduction. It's a privilege to be here today to try to start off a panel with some very, very talented members. And as Vikrant said, I'm just going to basically lay down the foul lines, if you will, for what this sort of discussion involves. I'm going to basically talk about 4 things today. First, what is overcriminalization? Second, how big a problem is overcriminalization? Third, why is overcriminalization a problem? And fourth, some ways that you can remedy this if you do think it is a problem. Let me start out first with what is overcriminalization. Overcriminalization is essentially a neologism used to describe the overuse and misuse of the criminal law for traditional and non-traditional means such as regulation. It can take its form in several different ways. For example, it occurs when there is the passage of too many laws oftentimes superfluous or redundant because they govern the same subject. It occurs when laws have too severe a penalty, and if they exist independently of each other, can be stacked atop each other to be used as a means of coercing someone because the charge carries such a tremendous penalty that it is necessary to plead guilty rather than go to trial. It can occur when you regulate conduct through the criminal process rather than through an administrative or civil process, which occurs, unfortunately, it has been on an increasing basis throughout the 20th century and has had little let up in the early part of the 21st. These are all different ways in which the criminal law is being used as a regulatory device in the broadest sense of that term, as a means of governing conduct. But the biggest problem with overcriminalization, I think, the worst case where it comes up, is where the criminal law is used to outlaw conduct that society traditionally has not deemed blameworthy. The reason why I think that is the single biggest problem in overcriminalization is this. Most people in America do not go to law school. They have real jobs. They work in different fields and acquire some subject matter knowledge of that field, which means they acquire some knowledge of some of the laws governing that field. But by and large, people learn what the law prohibits from family, from friends, from church, from school, and as I said, to some extent, from working in their own particular field. That is how we acquire the knowledge of what the criminal law will do to us when we cross a line. We learn over time what is and is not deemed blameworthy. And there has historically, throughout the centuries since the Norman Conquest, been a tremendous overlap between the criminal law and the mores of the community. What has been outlawed as a crime also historically has been outlawed as being immoral. Everyone knows you can't rob, rape, murder, etc. It's therefore not a surprise when you find that the criminal law governs the same conduct. You can rely on what you learn from parents, friends, schools, etc. to learn what the criminal law prohibits if the criminal law is designed to outlaw only blameworthy conduct. When, however, you use the criminal law in a much broader sense, as a regulatory device designed to deal with a post-industrialization age economy, you wind up in terrible circumstances because you don't anymore have the mores of the community as a go-by to know what is and is not a crime. Now, how big a problem is this? Let me just give you some examples. Most of it is deal with the federal government, and you will learn more about what happens in Texas and other states from my colleagues, so let me just lay some of the background. The very first federal criminal law, the Crimes Act of 1790, contained only approximately 30 criminal offenses, and each one was designed to deal with the immediate needs of the new government. It dealt with bribing judges. It dealt with assaulting customs officers, who were at the time the only people who were able to collect money because the only taxes the federal government imposed was in the customs field. There was no income tax or all the other things that we have today. So what you had was an effort by the federal government to avoid the risk that there would be a tremendous number of criminal laws out there, all the ones that were adopted focused on the immediate needs of the government. Well, that just turned out to be an acorn. Today, there are more than 4,000 federal criminal laws and potentially more than 300,000 relevant regulations, because the regulations sometimes will define primary conduct as being criminal or will define elements in a statute which has outlawed certain conduct. In other words, the statute may give you some definition of what is a hazardous waste, but you really need to look to the regulations to find out everything about that. So you have essentially 27,000 pages, if you will, of law that you have to look to in the federal system to get an idea for what the criminal code outlaws, and a lot of that is not aligned with the moral code that we all learned through friends, family, church, etc. Now, the federal government, as you will hear from my colleagues, is not the only one at fault here. In 2001, the Illinois Penal Code was 1,200 pages long. New York State has 150 different theft offenses, with penalties ranging up as high as life imprisonment. And as you heard Vic Krantz say, there are between 7 or 11 or 16 ways you can commit an offense with oysters in Texas, and that's just the ones you can talk about in church on Sunday. The opportunity for the criminal law to reach into areas of conduct that people are engaged in business, in private activity, or whatever, is enormous nowadays. Everyone knows you can't rob, rape, and steal. Not everyone knows whether what you're throwing in the garbage is a hazardous waste. And part of the problem is we have now expanded the scope of the criminal law to include conduct that the average person would not normally see as being a crime. And that brings me to the problems that overcriminalization presents, because the very first one is a lack of notice. The most basic requirement of any government that is offering a criminal justice system as a means of regulating society is notifying the public of what is forbidden. You have a limited opportunity to do that. You can rely on the things that the public learns in other ways, but otherwise it's the government's responsibility to tell you exactly what is and is not a crime. We don't have that ability anymore because you can't rely on the moral code. Historically, the biggest problem was whether a particular statute told you what was a crime. You had to know whether this was a tree, whether it was an oak, a willow, or whatever. Now the problem is not with individual statutes, it's with the entire forest. There are so many criminal laws out there that it's possible to stumble over them unknowingly, even though you are not the sort of person who the criminal law historically was designed to deal with. That leads to the second problem, the need for a lawyer. Historically, there was never any need to consult a lawyer before doing anything because everyone knew what the criminal law was because it matched the moral code. That's not so today. Ask small businesses. And it's small businesses that are the ones that are really at risk. If you're the CEO of DuPont, you have lawyers on your staff, and you have the ability to consult lawyers in the private sector. If you are the local dry cleaner, you don't. It's small businesses and individuals that have the biggest problem in this regard. The third problem also is one dealing with business, which is that overcriminalization leads to rent-seeking activity. That is, different components, different people in the commercial world will try to use the criminal law to protect themselves against competition. One way to try to enlarge your scope of consumer demand is to make it a crime for somebody else to sell the same product that you do. And so what you see then is businesses vying in the legislature for the opportunity to become monopolists or cartelists as a way of protecting themselves against competition from others. And the last problem is discriminatory prosecution. Historically, we've always thought that someone gets charged with a crime has done something immoral. But if everything you do is now potentially a crime, you no longer can have that presumption, which means people are at risk of being charged with crimes for the wrong reasons, a risk that should not exist in the society we have today. Now, there are 4 ways in which we can deal with this problem. We'll hear more about this, but let me just summarize it for you. First, don't pass any new criminal laws. Now, I'm not saying that there are no areas in society today that should not come under the umbrella of criminal law, because as developments occur, the criminal law should take that into account. Until there were automobiles, there was no need to deal with the interstate transportation of stolen vehicles. Until there were computers, there was no need to worry about computers being used to hack into banks or the federal government to get classified information. So yes, there is a need for it. But the Norman Conquest was in 1066. We've had centuries since then, and by and large, if something is going to be immoral or dangerous or hazardous to others, it's probably already a crime, and we don't need to make it a crime yet once again. Second, cull the unnecessary statutes. There may be a lot of them out there we don't need that create these problems, and maybe what the legislature could do is create a body that looks through the criminal code and sees what is unnecessary and presents it to the body in order for it to be repealed. A third is to make it a crime only if you act willfully, that is, only if you intend to flout the law. You know what the law prohibited, but you went ahead and did it anyway. That avoids the risk that someone could mistakenly cross the line into criminality without knowing it. And the last way to deal with it is from the other direction, which is to allow a mistake of law to be raised as a defense. If no reasonable person would have known that what is charged against this defendant is a crime, that defendant should not be held criminally accountable. And that's an easy fix. It's actually, in a way, the best defense sometimes is a good offense. You pass one statute that makes a defense available for anyone who can show that what he or she did was conduct that no reasonable person would have thought was a crime. In fact, it's even prosecution friendly because you can put the burden of proof on the defendant rather than require that somebody else deal with it. You are now going to hear from my colleagues about these issues as they relate to Texas. I want to thank you for the opportunity to speak with you here today, and please give my colleagues the same respect you've given me. Thank you very much.
Thank you, Paul. I'm next going to introduce a former law school classmate of mine, Representative Jeff Leach. He represents House District 67, which consists of portions of Plano, Allen, Richardson, and Dallas up in Collin County. Jeff really made a big splash during the previous legislative session. He earned all sorts of accolades. He was named a taxpayer champion by Texans for Fiscal Responsibility. He was named a Lone Star Conservative Leader by the Texas Conservative Roundtable. And he was named one of the top-rated conservatives in the Texas House by Texas Eagle Forum. He serves in the House Committee on Criminal Jurisprudence, the House Committee on Urban Affairs, and the House Committee on Rules and Resolutions. He attended Baylor University and earned his law degree, as I mentioned, from Southern Methodist University in Dallas.
Well, thanks. It's great to be here today. I'm tempted to just say what he said and then go sit down. That was really good, Paul. Thanks for being here, for flying all the way down from D.C. And it's really good to be here today. I want to talk about overcriminalization from the state perspective. And I guess to start, I should give you a disclaimer that I am not a practicing criminal lawyer. I practice commercial litigation, real estate, and construction law at Gray, Reed & McGraw in Dallas. So the extent of my criminal practice is when a client calls me when his son's been arrested in South Padre, or when a client calls me after getting a red light ticket, which I'm convinced I've probably dealt with about 5 to 10 red light tickets for the CEOs of pretty large companies, my clients, and they all claim at the beginning that they're innocent. And then all you have to do is show them the video, and 100% of the time they're guilty. And so that is the extent of my criminal practice. In fact, I try to avoid criminal practice, actually. So when the Speaker appointed me to serve on the Criminal Jurisprudence Committee for the 83rd Legislature, I had to dust off my criminal law books, some of my bar exam prep books, and try to relearn much of what I had forgotten about the basics of criminal law. One of the things that I learned very quickly on serving in the Criminal Jurisprudence Committee is what Paul mentioned, is how many criminal laws we actually have in statute in Texas. We have approximately, I think you're going to hear this from Shannon later as well, we have approximately 1,700 criminal offenses in statute in Texas. And approximately 1,500 of those offenses are found outside of the Texas Penal Code and or the Controlled Substances Acts. Think about that. 1,700 criminal offenses in Texas, and more than 1,500 of them are found outside of the actual Texas Penal Code. From our perspective as policymakers on the Criminal Jurisprudence Committee, we heard more bills in the House in the Criminal Jurisprudence Committee than any other committee. The Public Education Committee heard, for instance, 177 bills. The Ways and Means Committee in the House heard 210 bills. The Criminal Jurisprudence Committee heard 254 bills this session alone. And so it's clear that, as Paul mentioned, there is a desire on the part of some policymakers to create criminal statutes for one-time offenses. Shannon and I were talking earlier, one of the things that's illegal in Texas that's a criminal offense is for a barber inspector to sell barber supplies. And what happened there was it was a one-time situation where a barber inspector came in, having in his van new barber supplies that he wanted to sell, and he didn't pass the salon's inspection. And he said, but if you want to pass, I've got the supplies in my van to take care of it. And so one of our policymakers, either in the House or the Senate, I don't actually know who it was wasn't you, Representative Hughes, was it? Decided that they wanted to make that a crime. And so that statute passed, was signed into law by the governor, and is now the statute in Texas. It's actually a misdemeanor, punishable by up to 2 years in county jail and or a fine not to exceed $5,000 to do that. Another example, it's a Class C misdemeanor to practice interior design in Texas without a license. It's a third-degree felony for an athletic agent to give a gift to a college student athlete. Now, I think all of us understand the issues in the NCAA and that there's problems with paying and giving gifts to college student athletes, but these are things that the NCAA, through administrative remedies, handles, or at least they should handle. The question is whether we as the state policymakers, is this an area where the government should be playing referee? I don't believe it is. And I think that the general consensus is when you have 1,700 criminal offenses, 1,500 of which are outside of the Penal Code and the Controlled Substances Act, that we do have too many crimes in Texas. So the question is, what do we actually do about it? One of the things that we talk about a lot on the campaign trail and as policymakers, Republican or Democrat, one of the things that you're hearing a lot politically right now is limiting the size and scope of government. at the local, the state, and the federal level. We've realized that government is playing too big of a role in our lives, in our businesses, in our families, in often cases in our churches and in our faith. And so we talk a lot about limiting the size and scope of government. One of the questions I know we're asked a lot is, well, what does that actually mean? You can reduce taxes, you can reduce government spending, but what other ways are there that you can reduce the size and scope of government? I believe that, as Paul Larkin pointed out, one of the options that we have is to actually cull out unnecessary criminal laws. That's a good way to actually reduce the size and scope of government, to let businesses run, to let businesses operate unless there's actual culpable conduct on the part of a defendant, if there's actually a willingness. If there's a lack of willingness to create a criminal act, lack of the mens rea, then we shouldn't be holding businesses and/or individuals responsible for these acts outside of the penal code. And so, one of the things I did want to mention is Paul Workman is here today. Paul filed, I believe it was Representative Workman filed House Bill 2598. I think it was this past session, that would have codified the rule of lenity. The rule of lenity is basically a long-standing legal principle that places the burden of proof on the state when prosecuting criminal cases. And in essence, this rule requires these ambiguous criminal laws, such as the ones I've mentioned, to be interpreted in favor of the defendants subjected to them. And so I'm interested to get maybe Paul's comments later on the rule of lenity and how that might apply to Texas. We don't actually have that codified in statute right now. It may be something that we want to do. I don't believe Paul's bill didn't pass this past session, but we might want to bring it up again next session. So as a policymaker on the Criminal Jurisprudence Committee, the questions that we constantly ask when we heard all these bills is, are we enacting policies that aren't tough on crime, but that are smart on crime, that are right on crime? Are we being wise and good stewards of the trust placed with us with the voters, and actually considering these laws not just to pass and be tough on crime and to have more criminal statute, but to actually be smart? And I think that's what we did this past session. We just need to keep doing it next session when another 500 criminal bills are filed. So it's good to be with you today. I look forward to the discussion in a little bit. Thanks.
Thanks, Representative Leach. Next, we have Representative Brian Hughes. Brian represents District 5 in the Texas House of Representatives. He's a member of the House Appropriations Committee and the Subcommittee on Natural Resources, Business and Economic Development, and Regulatory Agencies. He also serves on the Committee on Criminal Jurisprudence. Brian also had quite a good session. He received the Torch of Freedom Award from the Young Conservatives of Texas, the Taxpayer Champion Award from Texans for Fiscal Responsibility, the Horizon Award from Texas Right to Life, and the Defender of the American Dream Award from Americans for Prosperity. He received his law degree from Baylor in 2008 and, in fact, was chosen as the Baylor University Young Lawyer of the Year. Please welcome Representative Brian Hughes.
Thanks, Vic. I was honored to get that award in 2008, and it won't, some of the people in the room can relate to this. The best part of being Baylor Young Lawyer of the Year was being officially a young lawyer. Huh? I mean that. Some of y'all know what I'm talking about. Bill, you know what I'm talking about. Not the lawyer. Because you are. Representative Leach was talking about his law practice. And Jeff, you mentioned you're not a criminal attorney. You know, many folks that vote in our primary think that's redundant, to use that term. But like you, I practice law, and I'm proud to. My practice is more in the civil area, like yours. I represent people and small businesses, and I don't do a whole lot of criminal practice. And so like Jeff, I enjoyed my time. I have enjoyed and continue to enjoy my time on the Criminal Jurisprudence Committee. It intersects our lives. It really intersects our lives a lot more than it should, hence our topic today. And so you've heard some great stuff. Paul, I've read a lot of your material and enjoy you being here. And Jeff set the table very well. And so those first two guys have done a nice job, and they've been respectful of your time. And so I'm going to remember the adage that I bet you know. It's not in the Bible, but it could be, and that is, blessed are the brief, for they shall be elected, right? Y'all have heard that before, or re-elected in some of our cases. So a couple things I want to mention. I want to tell you a story that Vic and I have talked about before, a true story about a lady named Brenda, and this is on a related matter, and it really goes to the heart of many of the reforms that we're working toward in our criminal justice system. These reforms are needed structurally because the way we've set things up, our prosecutors don't have a lot of choice, and you're going to hear more of that from an expert here in a few minutes. But this lady named Brenda lived up in my part of the state, back behind the pine curtain. And back in 2004, she bounced a check for $410.13. That's not good. That's against the law. We get that, and that needs to be dealt with. She'd never had any problems with the law before, and so this hot check came along, and the taxpayers of our county appointed her a lawyer, and they got her on deferred adjudication probation. And y'all may be familiar with that. If you are personally, you don't have to raise your hand. But the way deferred adjudication works is, if you complete that probation, then the offense goes away, and there's no record at all on your, well, not much of a record anyway, of no conviction. If you mess up, then you're brought back and found guilty. So this lady was put on 4 years, deferred adjudication, probation. Of course, that involved the payment of quite a number of fees. Our folks on probation pay probation fees and court costs and fines and things like that. And so did this all the way through 2008. Faithfully paid her fees, showed up for her meetings. But then late in 2008, the lady lost her job, didn't have the money to pay, and so she stopped going to her meetings. Bad idea, to her appointments. And so her probation was revoked in 2009, and she was sentenced to 18 months in state jail. 18 months. And so this is a $410 check. Over the course of that probation, this lady paid thousands of dollars in fees and in fines. But you know, of all that she paid, not a dime went to the victim for restitution. Now again, we can deal with it. We're making some progress in these areas, but it's one of those places that's sort of falling in between the cracks. We're against hot checks. We should do something about that. But let's be smart about it. And let me just say, one of the bills encouraged by TPPF has to do with victim offender mediation. So in those small property crimes like that, they're crimes. They need to be dealt with. But let's try to get the victim and the offender together and try to get that worked out. That way, the victim is made whole, right? And the person who's not yet a hardened criminal, we can keep them off of that path. So I'm encouraged about the progress we're making in those areas. But that story has really come home to me. And the issues have been framed well already this afternoon. When we think about locking people up and putting them in prison, there's a lot of folks that need to be locked up. You know, they're dangerous. They've done things that we want to punish as a society, and that's important. That's what prison is for. I think we'd all agree, if you look at some of these crimes, I would have put that in quotes, some of these crimes, we are locking people up today for things that we really probably shouldn't be. It's not good for them. It's not good for us. We can't afford it. And we are creating a whole new class of criminals. And beyond that, if we think about occupational licensing, now that's another whole area of reform. And we already touched on that some. A criminal record, depending on the occupational license you're seeking, can keep you from getting that license, from getting that job. And so these folks that have been in prison for whatever reason, we want them to be rehabilitated. We want them to have a job, to be productive in society. Whether you have any compassion for those folks or not, whether we do, it's in our interest for them to be working, paying taxes, right? We're for that. But this overcriminalization and these rules make it hard for those folks to get a job. So it's in all of our interests to look at this. And obviously you know that. You're here. I know I'm preaching to the choir. You get this. And I appreciate something Paul said, and Jeff mentioned this too. It's not just those statutes that we pass as the legislature, but those hundreds and thousands at the federal level of regulations passed by folks who we never see, who we can't vote for or against, and they can pass regulations with the force of criminal law. It's a real problem. It's a real departure from our biblical Western civilization view of criminal law and what the law is really for. So the good news is Texas is not in near as bad a shape as many states, certainly as the federal system, and like in many ways we can lead the way. Now as we think about the solutions, allow me to posit something that is slightly afield from our discussion, but when we think about government regulation, when we think about the best way to deal with conduct, maybe not criminal conduct, but conduct we want to deal with. For example, under the current law, we're concerned about air pollution and about water pollution and that sort of thing. And as a result, we as a society, acting through the federal and state governments, have a whole plethora of regulations, right? And I think we could agree they're overlapping, they contradict one another, they cost money, and they add the cost of doing business for every business. Whether your business is a polluter or is a clean company, you are burdened by all these regulations and just the maze that is out there. And may I humbly suggest that there's a better way. If our tort system if our tort system were allowed to work as it should, as it was designed, we could see a so much better system. For example, if I pollute Jeff's water, and rather than fining me and having the money go to the government and all the regulations that come with that, why don't we let Jeff bring a private cause of action against me? I'm the one that polluted his water. He brings suit against me. He proves I polluted his water. I've got to pay damages to him, not to the government, but to him. He gets made whole. I made an example. Other folks in the future know, hey, I better not pollute Jeff's water or anybody else's water. I may get sued. We don't have then these layers upon layers of regulation and rules that stifle competition and raise the price of goods for all of us. Now, I recognize, I get it, by suggesting the private cause of action, I am wandering off into traffic. I get that. That's sort of I know. And yes, I am a lawyer. Did I mention that? I practice law, represent clients for a living, and I'm proud to. Just those guys that wrote the Constitution were lawyers, and we're thankful for them. And it's a noble profession, needs to be redeemed. And so, along those anyway, and we're making some progress there too. But let's think about how the tort system might work. You know, those of us who profess fidelity to and love for the Constitution should remember that our founders, in addition to giving us the right to trial by jury in a criminal case, they also, in the Seventh Amendment, enshrined trial by jury in civil cases. They believed in the jury system. Are there abuses? Of course. Must we deal with those abuses? By all means. But let's don't forget that the jury system, the tort system, operating properly, is a wonderful solution to this problem. It moves us all down the road, improves our lives, and it improves the business climate. It means lower prices, more competition, freer markets for all of us. And so as we continue this discussion, I'm not here as an expert. I'm here to learn, but I'm thankful to be with these folks. I'm going to keep listening. Thank you for your attention this afternoon. God bless you.
All right, thanks, Brian. Our last speaker before we head into Q&A is Shannon Edmonds, who is the Director of Governmental Relations for the Texas District and County Attorneys Association. Shannon authors TDCAA's Legislative Update book, which is a comprehensive analysis of legislative changes that affect the state criminal justice system every session. It's actually a very, very useful resource. A big part of what we do, actually. We get it every 2 years. He has degrees from the University of Texas as an undergrad and also from the University of Texas Law School. He has worked as a prosecutor in Travis County. He has also served as Assistant General Counsel for Governor George W. Bush and as a policy advisor to Lieutenant Governor Bill Ratliff. Please welcome Shannon Edmonds.
Thank you, Vikrant. I have toys, so I'm going to bookend the conversation that started with Paul and put a little bit of a Texas spin on what he described at the federal level. And I'm going to start, though, with two disclaimers. First of all, I do work for the state's Prosecutor Association, but what I say here are my opinions and views only. CYA out of the way. The other thing is that if you thought this was going to be a point-counterpoint where I was going to come up and say, "Oh, you ignorant slut, you're so wrong." You know, that's an old reference to Saturday Night Live for those of you who weren't born when it was on. But in fact, I'm going to agree with much of what has been said here. And I actually went to lunch the other day with some prosecutors here from Travis County, where I used to be a prosecutor before I came to work at the Capitol. And I told them I was going to speak, and they said, "What on?" And I told them the subject, and they're like, "Yeah, every prosecutor thinks there are too many laws." And that may be an odd perspective for people who haven't thought about it a lot, but it's true, and I'm going to explain to you some of the reasons why. Now, this is the official title of this talk. I prefer to call it, that doesn't seem to be working, "Admitting you have an addiction is the first step on the road to recovery." Because our legislature, no offense intended, is addicted to creating crimes. And realizing that problem and the scope of it is one way to realize it's a problem and that something must be done to stop it. So, here is the little game we're going to play. I would like for you to guess the number of new criminal offenses that the Texas legislature has created in the last 5 legislative sessions. So, 5 legislative sessions. Anybody want to take a guess? You can just shout it out if you have a guess. 500, 200, 2,000. It only seems like that because you worked there a lot. Right? Okay, well, let's just go through year by year. 2005, we had 49 in one session alone. 2007, again, 50. Down to 40 in 2009. That's when we had all the chubbing, remember? Now, don't Google that unless you have Safe Search on. But it's a legislative term that slows down the process. And then, luckily, this last session, we had a little drop. But the total was 233 new crimes. And when I talk about new crimes, this is a little bit in the eye of the beholder, okay? But what I'm talking about are new sections of law, not an offense that exists and they add a new way to commit it. We don't count those. This isn't an existing law for which the punishment is increased. We don't count those either. We keep track of them. There were another 25 punishments that existed that were increased last session alone. That's not included in this number. These are new crimes. So we're talking an average of 47 things that used to be legal being made illegal by our Texas legislature. So here's the result. In 1993, we had a new penal code in Texas, all right? It was even deemed by one law review article as the best penal code in Texas in the year 2000 because of simplicity, clarity, ease of use. Now, we have over 225 crimes in our penal code 20 years later. Now, some of you are going, okay, Shannon, I know you went to law school, but you're not that bad at math. This doesn't add up. Where did all those other crimes go? Well, they're not going through the Criminal Jurisprudence Committee. They're going through every other committee in the legislature, to the point where we now have over 1,500 crimes that are not in our penal code. And the penal code is where those traditional moral statements by the legislature reside. 1,500, including more than 50 in the Business and Commerce Code, 40 in the Finance Code, and more crimes in the Texas Occupations Code than were originally in the Penal Code 20 years ago. All right? And this picture on the right is a publication that we started printing several years ago to keep track. Because guess what? Even the lawyers and the judges don't know where all these crimes are. So we had to create this book, which is for sale at the link below, as long as, and that's why I come to do this, because I get a free pop for, yeah. Well, Shannon, it's all very interesting, but guess what? Nobody really cares. We used to go to the legislature every session, back in the days before social media, and maybe even really email was popular, and we had a little one-pager that we would we put in the mailboxes. Remember the old mailboxes, for those of you who've been around? That basically said, before you create a criminal law, here are other things you may consider as policy options to address this problem. They all ended up the same place that most of the things that got put in those mailboxes ended up. File 13, that circular one in the corner. But fortunately, TPPF cares. Yeah, and that's one of the reasons why I enjoy coming here, because one of the things, this is a slide from one of Mark's old presentations. I want to focus on this bottom one here, which talks about not using criminal law to grow the government. Okay? So here's a more elegant way to put it. Whoop, sorry, we're going backwards here. This is a famous quote, okay, from one of the founding fathers of the limited government movement. Here's the point I want to make. You can't shrink government if you keep giving government more to do. Because the thing about a criminal law is that only the government can enforce it. You're taking it out of the civil system that Representative Hughes was talking about and tasking the government with enforcing it. So simultaneously giving it more to do while you want to try to shrink it, it doesn't make sense. It doesn't compute. Another reason you should care is something that Paul brought up, which is you, in your own self-interest, need to be careful. Now, there is a famous article written about the federal law that says each of us commit 3 federal crimes every day. That's horse hockey, okay? But the sentiment is one that's well taken, is that many of us don't know those laws out there. Even the lawyers charged with enforcing and hearing the laws don't know what all these crimes are, which means if it's too big for the experts to handle, you can't expect Ziggy off the street to know what is right and what is wrong. One reason why this happens that wasn't mentioned by Paul is the only one I'm going to talk about because this slide came from Pennsylvania after the Penn State Sandusky sex abuse incidents. This is a reaction we frequently see from our legislators, whose constituents call them and say, do something. This is horrible. Something must be done. And so, what do legislators do? They legislate, right? Just like prosecutors prosecute. Trying to tell a prosecutor not to prosecute a crime, they go, that's why I ran for this office. And that's why legislators ran for their office, to legislate. So this is the knee-jerk reaction. What needs to happen is the education of policymakers about other alternatives that are out there. Boy, this thing's going crazy, isn't it? Yeah, was it there? That's what happens when your clicker doesn't work. All right. So, we've got a bunch of bad laws. Laws that have never been used, okay? We made it a crime in Texas to practice chiropractic while intoxicated. Now, I don't know who was the poor person on the table that had the drunk cracking their back, but does that need to be a crime? I don't know that that law has ever been used since, okay? But it's on the books, and it's a felony. Someone can go to prison for it. So why do we tolerate these bad laws? Well, we see a fence like this, and we think this is idiotic. Fail. Let's get rid of it. But I am going to urge a little caution before we start taking down all the fences that have been put up. And I didn't come up with this. This is a famous conservative thinker named G.K. Chesterton. Some of you may be familiar with him. And he had something called the fence paradox. 100 years ago, he was fighting progressives who wanted to undo a lot of the things that existed in society at that time. And he said, okay, progressives, before you come down and say you want to take this fence down, what you need to do is tell me, why was it put up in the first place? And if you can't tell me why that fence was put up, you shouldn't be allowed to take it down. And that's an easy fence rule to follow. Because a lot of times, that fence may not have been put up for the reason you think it was. It may not have been for your protection. It may have been for someone else's protection. And so it's important before you undo something that's been through the legislative process that you understand why it was put up. Because, this makes perfect sense if you're trying to keep people from driving their vehicles on something that was only meant for pedestrians, right? And maybe this solution was cheaper than tearing up all the pavement. And so it was the smart decision at the time. But until you know why the fence was put up to begin with, you can't begin to take it down. So, let me finish with something that I think segues to what Representative Turner said in there. His final quote, I didn't get down exactly what, basically it was, if you want to know about the fate or the external fate of a nation, you have to look to its heart. You have to look inside of it. The reason we have so many crimes in Texas is partly because of something that Supreme Court Justice Oliver Wendell Holmes Jr. pointed out, which was there aren't any laws in heaven, but there are a lot of them in hell, and due process is strictly enforced. If we had a society that would quit wronging each other, we wouldn't need to bring the government in. And just to piggyback on something that Representative Hughes said. He is a braver man than I, because I have had a slide in this presentation that blamed tort reform for some of the overcriminalization, and I took it out. But I think it's true. I think it's accurate, because when people are wronged, they want justice. We're Americans. We're all about justice. And when you limit the justice that someone can get in one venue, it's natural for them, in this case a civil court, it's natural for them to go and seek refuge and seek a solution someplace where the legislature is happy to create criminal laws. And guess what's great about making something a crime? All the people who are victims, they get free lawyers. They're called prosecutors. And to that victim, they are free. But to all of you paying taxes, they are not free. Okay? And so the more work our members have, the less they're able to give the time and resources necessary to resolving each of those issues properly. So those are all things to think about. I know we're going to take some questions, and I hope you've enjoyed my little show, technical problems notwithstanding. Thank you.
Thanks, Shannon. All right, we will turn to questions now, and I always take the privilege of asking the first question since I'm the moderator, so I will ask about this term that came up a couple of times, mens rea, this notion of a person's mental state when they commit a crime. We have always been told, I mean, this is something that people have known since they were little kids, that ignorance of the law is no excuse. You can't just go around saying, well, I'm sorry, I didn't know that was a crime. And yet we had a lot of our panelists today saying that they feel like ignorance of the law is a legitimate excuse. I mean, why is it that ignorance of the law is not an excuse, is disappearing in your view as a justification? Paul?
The rule that ignorance of the law is no excuse is one of the most ancient propositions in the criminal law, as you point out. It dates from the very foundation of a criminal law. But that's because at the foundation of the criminal law, back in common law centuries ago, there were only 9 crimes. And like rape, rob, murder, etc. And each one of those crimes was a crime not only against the king, but it was a crime against God. Everyone knew what the criminal code prohibited because everybody knew what the moral code prohibited. So the idea that you should be able to come in and say, well, on the one hand, I knew that it was immoral to murder, but I didn't know it was a crime to murder, was preposterous. So there was no need to allow someone to raise a claim that he or she didn't know what the law prohibited because everyone knew what the local rules of ethics and mores were. That's not the case anymore. What we have now is a vast expansion in the number of criminal statutes that make something a crime, not because it's inherently immoral, but simply because in a cost-benefit sense, it's better to have this be a crime and better to have it in the criminal justice system than in the tort system, or at least that's what legislators think. But a lot of that sort of conduct, a lot of that activity is not conduct that people would ordinarily know to be a crime. Even lawyers wouldn't know that. I mean, Bill Stuntz, the late professor at Harvard Law School, said that generally speaking, lawyers, judges, and law professors don't even know what's in their own state criminal codes, at least not the entirety of it. If that's the case, it's unreasonable to hold a reasonable person to conduct that no reasonable person would know is a crime.
Let's turn to the audience. How about Ed's go? Oh, yeah, Shannon, please.
The only cautionary tale is, I think that's true. The solution should be repeal that crime if a reasonable person doesn't know that that should be against the law. The problem, we have a provision in the penal code that says mistake of law is not a defense unless you're relying on, for instance, an AG opinion or a court case. And you say, hey, I thought it was permissible under what the Court of Appeals said. And then you may have a defense. But you have to worry about, you have to be aware of unintended consequences when you do that. And the thing that popped in my mind, Paul, when you said, there should be a rule that it's not a crime if a person of ordinary, how did you phrase it?
Ordinary intelligence.
Ordinary intelligence wouldn't think it's a crime. Well, guess who created that crime? The Texas legislature. Are they going to pass a law that says we're not of ordinary intelligence because we made it a crime, but it shouldn't be? I don't think so.
Shannon, we should recall Molly Ivins' words on that. She said, if there weren't a certain amount of ignorance in the legislature, it wouldn't be representative democracy.
I'd like to make a comment on that.
Well, hold on, Paul, you wanted to respond to
I just
Shannon's
want-
point. Yeah.
Let me start with Nancy Pelosi's famous phrase that we need to pass Obamacare to learn what's in the statute. The idea that legislators will read through every provision in every bill that is passed is a fiction. I worked for Senator Hatch when he was the chair of Judiciary Committee, and I was the head of the crime unit, and was sitting there on the Senate floor. I got a great experience in how, you know, these things actually get passed. The Democrats come through one door, the Republicans through the other, and as every person walks in, they get handed a little card that tells them what the name of the bill is, what the number is, and how they're supposed to vote. And a lot of them, simply because they just don't have the time, because they're working on other issues on other committees, don't go through every bill and find out what's in it. If you're the chair of the Armed Services Committee and your job is to help oversee what the Pentagon is doing, you could do that 24/7, 365, and still not be able to learn everything they're doing. It's not a question of calling someone ignorant if they don't know what the law is. And in any event, the literal meaning of ignorance is just not knowing. It's not, you're not saying that someone is stupid, that they can't mentally process something. You're saying somebody is ignorant of something. I'm ignorant of nuclear physics and 1,000,001 other things. I just don't know them. You're not trying to make a moral judgment that a person is or is not in the legislature incapable of knowing what he or she is doing. What you're doing is recognizing the reality that a lot of legislators will vote for things simply because they trust their colleague. And a lot of legislators become experts, and so their colleagues justifiably rely on them. But the average member of the public shouldn't be held criminally accountable. I'm not saying there shouldn't be administrative remedies or tort remedies. I have no complaint with the administrative state or the civil process. But making something a crime and holding somebody criminally accountable for what the average person wouldn't know is a crime seems to me to be a misuse of the criminal process.
Yeah. And I just think it shouldn't be made a crime. That shouldn't be made a crime.
Okay, with all due respect, mistake of law is a defense if you are the government or acting in the name of the government. It's called immunity. The immunity doctrine began to be developed by our Supreme Court after the fallout from the Nixon administration, when Nixon and his administration gave orders to the FBI and every law enforcement police station in the country to violate the law with impunity to crush the anti-war movement, resulting in a lot of false arrests, false prosecutions, bringing cases against prosecutors, police officers, government officials for their crimes. So they developed these immunity doctrines. The constitutional fence has been taken down. There is no Constitution. And our legislators do not pass laws, they pass suggestions that judges may follow or may not, that prosecutors may follow or may not, that police officers may follow or may not. Those who we pay to know the law are the only ones in our society that can claim mistake of law, ignorance of the law, and get away with it.
And I have to ask whether or not you've got a question.
Yes. Will our Texas legislature restore the Constitution, restore their laws to something more than suggestion? Will they hold prosecutors accountable? Will they provide restitutions to their victims? I'm one of their victims.
Well, we've got two legislators here. We can turn it over to them. Ryan, Jeff?
Vic, can you clarify the question for us? I could probably talk for 30 minutes responding to what you said, but what's the actual...
Okay, I proved in a court of law in this state that I committed no crime. And it was obvious to the prosecutor and the judge that convicted me that I had not committed a crime. The conviction was overturned, reversed, and I was declared actually innocent. I then proved my damages in a court in this state. My property damages, nothing more, no tort damages, property damages, property loss.
Ed,
The illegal prosecution and the legislature says that the government is above the law. The government can steal, the government can rape, the government can kill you, and they are above the law. They have sovereign immunity, they say.
Okay.
Representative
No,
Hughes
thanks.
and Leach, please feel free to respond, but otherwise, it sounds like a personal issue that you should feel free to discuss afterwards.
Yes,
sir.
answer now. Ed asks it every
Right,
year.
and so, okay, and so let me,
It's the reason for why we have the highest.
Let's
incarceration.
allow Representative Hughes to speak.
I'd love to
He was-
respond.
He was speaking.
Yeah.
Ignore the law that says their job is not to
Yeah.
convict, but to see that justice
seek
is
justice.
done.
That's right.
They think their job is to
That's
convict.
right.
Even if no violation of the law has been committed,
when I was
they're
a-
going to try to defeat the law,
Yeah.
defeat the Constitution, to secure a win
Yeah.
in their column.
I had the privilege of serving as a law clerk for William Steger, who was a hero, World War II fighter pilot, wonderful guy, a U.S. attorney, one of the youngest in the country, later became a federal judge. When he was an old prosecutor, and he told us, in a criminal case, when he would give the charge to the jury, he told the members of the jury, you should never ask yourself if the government will win this case. The government always wins when justice is done. And we believe that. Now, does it always work out? I don't know. I hope it does. As far as sovereign immunity goes, that didn't start in the 1970s. That's an English common law since the memory of man runs not to the contrary thing. It's good to be king. You can't sue the king. Now, let me finish. Let me finish.
Let him finish.
We waive sovereign immunity, as you know, in certain cases. The Texas Tort Claims Act, if you're harmed in this certain way. We also waive sovereign immunity for civil rights violations. And the one solution, of course, is to come to the legislature and ask for a specific waiver of sovereign immunity to allow suit. I carried one of those in the past. It passed. Governor Ratliff did one of those for a constituent of mine. So the system normally works. When it doesn't, there are ways to deal with it. I don't like sovereign immunity in principle, but I know why it's there. But it's not something we invented or started with Richard Nixon. It goes back a few centuries.
Yeah, one of the things I'll mention, in the 83rd legislature, we took substantial steps toward addressing the issues of prosecutorial misconduct. I joint authored with my good friend Ruth Jones McClendon from San Antonio the Timothy Cole Exoneration Commission, and I know there were issues with that. It ultimately didn't pass. We passed the Michael Morton Act. This issue was addressed head on this past session. We've got more work to do, and you can shake your head, but I can give you.
The Act did not say anything that was not already said. That was not
Ed,
already
let's let Representative Leach complete his answer.
I understand. I think both Representative Hughes and I and everyone else in this room understands that you're upset, and I'd be happy to talk with you about your personal situation and how we might be able to help. Having said that, I can tell you from personal experience that this was an issue we took very seriously, and I agree with your statement that prosecutors should not be seeking to win. Prosecutors should be seeking justice. And as the legislature, we're going to protect the rule of law. And if there's prosecutors that are knowingly and intentionally withholding evidence or whatever in order to win, then we're going to address that head on and take care of it and make sure it doesn't happen anymore in Texas. I feel very strongly about that.
Hayden, I think we've got a question in the back.
Great. Thank you. Mr. Larkin, I really enjoyed your presentation. I wanted to ask you a question. You outlined 4 points of ways to combat overcriminalization, and the fourth one was to create some sort of defense of men's rights, reassert some sort of defense of mens rea or something like that. Do you know if any other states have actually adopted that legal principle or have tried to incorporate that to their criminal statutes?
The last two recommendations deal with mens rea, but they come at it from different directions. One is to define for new crimes, particularly if it's in a regulatory area, particularly if it's not one that would be deemed inherently immoral, dangerous, or risky, that the defendant act willfully. The term willfulness is one that the Supreme Court has defined in a series of cases since 1977 as meaning the intentional violation of a known legal duty. Now, there are various statutes that use the term willfully. For example, the federal tax code. You can be convicted for violating certain federal laws only if you act willfully, only if you know you're not entitled to the deductions, claim them anyway. So there are certain provisions in federal law that have that, and they are scattered throughout the different federal codes. How many states have that provision, that sort of limitation, I don't know. I doubt they have any limitation like that for what would be considered common law crimes, murder, rape, robbery, because you wouldn't need it in those, in part. Hopefully they might have it on regulatory crimes that aren't dealing with conduct inherently dangerous, et cetera, but I'm not sure. The other way of dealing with this sort of mental state problem is through a mistake of law defense. The mistake would have to be a reasonable one. Only if no reasonable person would have thought that what is charged against me was a crime would I be able to raise this defense, which is a way of eliminating scores of problems, because you could never come in and say, I didn't know it was illegal to possess heroin. I mean, possession of heroin, heroin probably didn't exist at common law, but they had perhaps had opium, didn't matter. That wasn't a crime then. Everybody knows it is now. Kidnapping was not a crime at common law. Everybody knows it is now. So a reasonableness limitation in this regard would ensure that people who are individually unblameworthy, non-blameworthy, would not be convicted, but it wouldn't just open the door for everybody to walk through. Few states, if any, I think, have looked at it that way. Most usually allow this evidence to come in if the statute requires proof of willfulness, because the Supreme Court in a case called United States versus Cheek said that if the statute requires you act willfully, then you can show that you didn't act willfully by showing you didn't know this was a crime. But the sort of ways I've recommended looking at this are relatively new. The mistake of law defense is laid out in some articles I've written, but it's an entirely new way of looking at the problem.
I think we have time for one last question, so let's take this before clearing out the room.
In some of the states, there is a rarely used process known as jury nullification. I'm not sure if that exists in the state of Texas or not, but I think in that process, a jury can find a certain law so utterly preposterous that it can nullify and void a law. Is that true in the state of Texas as far as anyone knows?
Yeah, Representative Hughes.
Yeah, great question. So jury nullification, I mean, it exists de facto everywhere because, in a criminal case, a jury can find a defendant not guilty, and they don't have to say why. They don't have to tell us it's because I disliked the law. They can just say not guilty, no questions. The state cannot appeal that. I don't guess there's any exceptions to that. And so now there was a bill that we had in crim jury last time that looked at the concept of jury nullification, because even though the jury can do it, you're not really allowed to tell the jury, and I'll defer to real practitioners on this, but if you as a lawyer get up and tell the jury, hey, you can ignore what the judge said and you can say not guilty for any reason, that creates kind of a problem. I'm one who's in favor of more robust jury nullification. There was an old senator from Idaho that used to say 3 boxes protect our liberty: the ballot box, the jury box, and the cartridge box. And I agree with him. And it's true. It's really true, And that's service on a criminal jury. In my view, as a citizen, you have a right to determine not just the facts, but you have I believe, a duty to determine, is this a just law? Now, there are concerns about jury nullification because what if I said, you know what, I think that the law is unfair to people from East Texas. And so whenever I see a defendant who's from East Texas, because we've been so discriminated against and treated so poorly, I'm going to find him not guilty just to kind of even the score. So there's a concern that jury nullification could be abused. But yes, the jury always has the right to do that. You can't really tell them about it, though. I'll defer to anybody else on that.
No, I think we have 10 because no one's going to top the cartridge box line. So I want to thank everybody for attending today, and I want to thank all 4 of our panelists. Thank you very much.